Hello friends, in the series on income tax cases, today we will discuss a very important issue on the instruction of the department regarding disclosing the nature of the scrutiny in the notice under section 143 subsection 2. Recently it has been seen that some tribunals have quashed the assessment proceedings on the basis that the notice under section 143 subsection 2 does not mention the nature of the scrutiny, that is whether it is manual, whether it is complete, or whether it is limited scrutiny. The issue before the tribunal in the present case was that if some instruction is being issued and if that instruction is not issued under section 119 of the Income Tax Act 1961, so whether that instruction will be binding on the income tax authorities. This issue has been taken up by Chandigarh ITAT B bench in the case of Vimal Alloys Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal at page number 586, and the date of the judgment is 21st January 2026. In the present case, the assessment of the assessee was completed under section 147 and for that year the assessment has already been completed by the department under section 143 subsection 3. The assessee was challenging the assessment order on the various grounds, and one of the ground was that the notice under section 143 subsection 2 does not mention the nature of the scrutiny, that is whether it is limited, complete or manual. For this the tribunal said that the assessee, which is relying on the instruction dated 23rd June 2017, do not any force of section 119, meaning thereby that it has been not issued under section 119 of the Income Tax Act. The tribunal said that only those circulars, only those instructions which are issued in exercise of the powers under section 119 are binding on the income tax authorities. In the present case, the instruction which the assessee is relying, dated 23rd June 2017, could not be regarded as a statutory instruction because it is not issued in exercise of the powers under section 119. The tribunal said that at the most these instructions can be treated as internal administrative guideline or office instructions meant for procedural guidance of the field authorities. So the tribunal denied to entertain this ground of the assessee. For other grounds, the tribunal said that in the present case the proviso to section 147 applies. The assessment of the assessee is already completed under section 143 subsection 3, and the assessing officer has grossly failed to even mention in the order under section 148A clause D that the assessment of the assessee is already completed under section 143 subsection 3, and the assessing officer has not mentioned in the order that what the assessee has failed to disclose in the original assessment, due to which there is need to issue the notice under section 148. Since the assessing officer has failed to complete the jurisdictional requirement, which is very sine qua non, so the assessment is bad on this ground that the assessing officer has not cleared that whether what the assessee has not disclosed in the original assessment. Clearly the proviso to section 147 applies. The tribunal said that the assessing officer has not told which material fact the assessee has not disclosed in the original assessment, due to which there is need to do the reassessment of the assessee. The tribunal said that apart from that, no independent inquiry has been done before issuing the notice. It has been issued on borrowed satisfaction. There is no live link between the material in hand with the assessing officer and the assessment of the assessee. Moreover, the material relied on by the assessing officer has not been provided to the assessee. The objections of the assessee has not been disclosed. There is no cash trail found, only the allegation of the bogus purchases has been made. The tribunal said that the opportunity of cross-examination has not been given to the assessee in spite of repeated reminders by the assessee, since from the assessment records it is very clear that the assessing officer has relied on electronic records, but the requirement of section 65B of the Indian Evidence Act 1872 has not been complied with. The books of accounts of the assessee has not been rejected and the sales has been accepted. So in the present case, the addition for the bogus purchases is not justified. At the end of this video, once again I am repeating the name of the case. The name of the case is Vimal Allies Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal at page number 586, and the date of the judgment is 21st January 2026. Thank you, friends.